the AG's office is getting ready to log in right now. They had another one going, but they're going to log into yours first.
Okay, great. Thank you.
Okay, you're welcome.
All right, Mr. Burke, are you able to hear me okay?
I sure can, Judge. Hi, good afternoon. How are you?
Good afternoon, thank you. All right, we're on the record in People versus Rachel Gann, case number 236641. If I could have counsel put your appearances on.
Judge, good afternoon. For the record, my name is Mark Burke. My P number is 54935. I'm with the Attorney General's Office paying for the people.
Thank you, Your Honor. Larry Brown on behalf of Ms. Gann.
Was Ms. Gann able to make it?
She was not, Your Honor. I did inform the court this morning. She called me at about 9:30 this morning. She lives about 4 hours away. I apparently had some car trouble. I did advise her that the court, when I got an email back, that the court did require her to be here in person, but she did inform me a little later that she was not going to be able to make it.
Okay, Mr. Burke, were you able to hear that?
I was, Judge. Yes, thank you.
Yeah, so just to make a record, I did get a notice from Mr. Brown this morning asking for Ms. Gann to appear by video because of car trouble. I don't know whether that's true or not. I'm always a little suspicious when somebody who particularly lives far away on the morning of a hearing calls and gives a reason like car trouble. That it's very easy to just say that so that they don't have to drive to the actual hearing and want to appear by Zoom. So it's my practice not to allow that when it's scheduled as in person. So I think under the court rules as they stand, Mr. Burke, unless you have a different thought, I would set this for a show cause hearing. Mr. Brown, please let Ms. Gann know that I'm going to need some type of documentary evidence that she actually did have some kind of car issue today.
For the record, I did let her know that, Your Honor. I told her to bring receipts or anything she has.
Okay. And then if she fails to appear again, the court would issue a bench warrant for her arrest. Otherwise, or if she's not able to provide adequate proof that she had some kind of reasonable excuse for not being here today. Otherwise, we'll proceed at the next hearing. Mr. Burke, do you have any objection to that or any record that you wanted to make?
No, Judge. No objection to that. I think that's fine. I was going to ask for a bench warrant, but if the court wants a show cause to allow the defendant to provide documents verifying her situation today, I naturally I don't have a problem with that, Judge. Do we know when that show cause is going to happen?
I don't, but my office will send out notice of the date and time, and Mr. Burke, you're free to appear by Zoom for that if you'd like.
Okay, very well, Judge. Thank you so much. Appreciate that.
Okay, thank you. You're free to disconnect at this time.
Judge, have a great day. Thank you. Mr. Brown, thank you.
Thank you, sir.
Mr. Thompson, are you ready with Mr. Edwards' case?
Not ready yet, Your Honor. If I could have a few more minutes.
Mr. Brown, do you have any clients present that
I don't know if Mr. Alma is here yet.
Something else coming in. Alma.
do you need to speak with Mr. Alma?
I could speak with him for a couple of minutes. I spoke with him just a couple of days ago, but
Okay, that's fine. Let's take about a 5-minute recess and then we'll come back up. Okay, are you ready on Mr. Alma's case?
Yes, Your Honor.
People versus Maurice Alma, case number 236665. Mr. Alma, can you come forward, please?
And for the record, Your Honor, Michael on behalf of people.
Larry Brown on behalf of Mr. Alma.
Mr. Alma? Step to the podium.
Yes, sir.
All right.
Hard of hearing, I apologize.
Oh, okay. Thanks for telling me. I'll try to speak up.
Yes, sir.
Mr. Brown, how are we going to proceed today?
Your Honor, this is a status conference here for felony operating while intoxicated. I have spoken with the prosecutor. There has been no offer in this matter. However, I have spoken with Mr. Alma regarding this matter previously, as well as just a few minutes ago. At this time, I believe we are just going to plead as charged.
Okay, Mr. Alma, you're going to enter a plea to the charge today, is that correct?
Yes, sir.
Can you raise your right hand, please?
Yes,
Do
sir.
you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you.
Your Honor, I had one more thing to mention. In my conversations, he indicated that he was not on any type of probation. However, I believe that I was looking through the file and did a stip to cancel his bond because he was in Crawford County. I just want to make sure that he's actually not on any probation.
Are you on any kind of probation?
No, sir, I did not receive probation at my sentencing, excuse me.
Okay,
Yeah, I had my jail time and,
okay,
I may be wrong in the matter, but 99.9% sure that's what they told me, because I'm not reporting to anybody as well.
okay,
Yes, sir.
all right. Okay, so in this case, you're going to be pleading guilty to one count of operating while intoxicated as a third offense, and the maximum possible penalty for that charge is up to 5 years in prison and or a $5,000 fine. You understand that?
Yes, sir.
Okay. What is your plea to that charge today?
I plead guilty today, sir.
All right. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to get this plea reversed, you would have to ask the Court of Appeals to hear your case. If they said no, that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
All right, this happened on June 2nd of 2023. Is that correct?
Yes, sir.
Okay. On that date, had you been, let's see, Mr.
This was marijuana, Your Honor.
Marijuana, okay. On that day, did you consume some marijuana?
Yes, sir.
All right, and after you consumed that marijuana, did you operate a vehicle on Old State Road here in Otsego County?
No, sir. I don't mean to just, it was just past Old State Road on 27.
Okay,
It wasn't actually on Old State Road,
Okay.
but yes, sir. And then the officer come up behind me, pulled me over.
okay, down by the south end of Otsego Lake there, is that where you're
Yes,
talking?
sir.
Okay. All right.
Correct.
And at the time that you were operating that vehicle, Did that marijuana interfere with your ability to operate that vehicle in a normal and safe manner?
According to the law, yes, sir, it did.
Okay, what were you doing to get pulled over?
I had an older vehicle, I haul scrap metal, and it was bad. It was kind of wavy with the trailer, and that was his initial stop.
Okay, did you have any field sobriety tests done?
Yes, sir.
Okay,
And took me in and had drew the blood as well and had me blow the thing. Just
okay.
yes,
Do you have any reason to doubt the results of any of those tests if they showed that your level of marijuana made you unable to operate that vehicle in a normal and safe
I have
manner?
no dispute of that, sir.
Okay. All right. Had you previously been convicted of operating while intoxicated here in the 46th Circuit in 2020?
I'm not sure if that's what the record states, and I have no reason to dispute it.
Okay. And if the record says that you also were convicted of operating while intoxicated in 2004 in Crawford County, would you dispute that?
No, sir.
Okay. All right, Mr. Roller, are the people satisfied with the factual basis?
People satisfied for sufficient factual basis to accept defendant's guilty pleas to count one, has complied with courtroom statute as to acceptance of pleas, and we're aware of no threats, promises, or other inducements not placed on the record.
Thank you. Mr. Brown?
I'm also satisfied with the factual basis. The court has complied by statute, court rule for taking of pleas. I am also not aware of any promises, threats, or inducements that have not been placed on record.
Okay. All right, Mr. Alma, the court is going to accept your guilty plea. I find that it's knowing and voluntary and accurate, and I find there is a factual basis to support a finding that you are guilty of this charge. You're going to meet with Ms. Davis here from probation before you leave the court today,
Yes, sir.
and then we'll send you notice of the next hearing.
Okay.
It's important that you stay in touch with Mr. Brown, your attorney, before that hearing, okay?
Yes, sir.
Do you have any questions?
No, sir.
Okay, thank you.
Oh, yes, I guess I do. Now, Ms. Davis is ready for me. That answers that question.
Okay,
Thank you.
yeah, you're welcome. Where's Mr. Thompson? Deputy, can you go get Mr. Thompson and tell him he needs to bring Mr. Edwards in here? It's not already in here. All right, thank you. All right, Mr. Thompson, you can bring Mr. Edwards right up to the podium here. We're on the record in People versus Landon Edwards, case number 226434. If counsel can put your appearances on the record.
Thank you, Judge. For the record, Mike Roloff, the acting people.
Thank you, Honor. Jason Thompson on behalf of the defendant.
All right, this is set for a final status conference here today. Yep, this set for trial to proceed on March 1st. This would also be the plea cutoff. Mr. Thompson, how are we going to proceed?
Your Honor, as far as I've been advised throughout this case, Mr. Edwards intends to exercise his right to a trial.
Okay, Mr. Edwards, is that correct? You want to proceed to trial in this case?
Yes, sir.
All right, you understand that today would be the last day to enter a plea to any lesser charges?
Yes.
Okay. All right, so we have trial set for March 1st. It looks like Mr. Rowley, you've already submitted your final witness and exhibit list.
Yes,
along-
Judge.
Along with your proposed instructions.
Correct.
Okay, so Mr. Thompson, the court's just gonna request that prior to trial that you submit any objections to any of Mr. Rowley's proposed instructions or verdict form and any additional instructions that you would like. And copy Mr. Rowley on that, along with your final witness and exhibit list. And Mr. Rowley, anything further on behalf of the people that we need to address today?
Not in this file, thank you.
Okay, Mr. Thompson.
Your Honor, I believe that the witness I had identified, the other passenger in the vehicle, I believe we prepared a writ for that subpoena. I believe the court had in fact signed that. So I believe that's been sent to MDOC and that's all in order.
Okay. All right, you may just want to follow up on that as we get closer to the trial date. Otherwise, Mr. Edwards will just need you to be here by 8:30 on the morning of March 1st, and we'll proceed with trial and jury selection. Did you have any questions at all, sir?
No, sir.
Okay. Mr. Roll, anything else we need to address today?
No, Judge.
Mr. Thompson?
Nothing further. Thank you, Your Honor.
Okay, that's all for today, Mr. Edwards. Thank you. People versus Campbell Curvella, case number 246672. We have Avery Grace Campbell Curvella present here. You can come right up to the podium there. If I can have counsel put your appearances on.
Amanda Brooker, appearing on behalf of the people.
Mr. Brown, how do we want to proceed today?
Your Honor, this is my first appearance in circuit court. It's a relatively new case. An interesting case because I'm also dealing with some juvenile issues with her. There was a new charge for a retail fraud that just came down. And there's a lot going on in this current felony case. So I am going to ask the court for at least a 30-day adjournment.
Judge, I have no objection.
Oh, I'm sorry, Ms. Krueger. All right, Mr. Bella, your attorney is indicating that he wants a little more time to be able to go through some of this with you. If you have any objection to that. So we'll set this for another status conference in about 30 days. In the meantime, Mr. Bell, you need to make sure that you stay in touch with Mr. Brown so that you can help him prepare for how you want to proceed, okay? Mr. Rowland or Ms. Krueger, anything further on this case?
Judge, can we address one point on bond?
Sure.
She has some bond conditions that were put in place when she was arraigned, and one of the bond conditions prohibited her from having contact with her grandparents. Mr. Brown and I agree. I put a stipulation for the court to lift that portion of the bond conditions. There still will be a no contact order with the alleged victims or her parents in this case. But we just want to lift the portion regarding her grandparents.
Okay, are you gonna?
I have it right.
Oh, you do, okay.
Yes,
If you want to approach. Sign that, and so Mr. Brown, just make sure that you go through with Mr. Bell so that she fully understands what her restrictions are going to be and how this changes things.
Yes, sir.
Okay.
Can we get an updated address, Your Honor? Because notices are coming back.
Oh, okay. Ma'am, can you give us an address? We're getting mail that we sent to you returned.
1867 Wyatt Road.
Okay, what was that again?
1867 Wyatt Road in Standish, Michigan.
Can you spell that road?
WYATT.
Okay. And what was the city again? I'm sorry.
Standish.
Standish. Do you know the zip code?
48658.
48658. Thank you.
Do you have any questions at all? All right. People versus Eric Splan, case number 226635.
For the record, Your Honor, my call on behalf of the people.
Mayor Brown on behalf of Mr. Swain.
Right, the record should reflect Mr. Splan is present here in the courtroom today. And this is the date and time set for sentencing in this matter. Mr. Spillane, did you get a chance to go through the pre-sentence report and talk to Mr. Brown about that? Yes, sir. Mr. Brown, are there any additions, deletions, or corrections to that report?
No, Your Honor, and no challenges to this.
Mr. Rolla, do the people have any additions, deletions, or corrections?
Just one correction, Judge, at page 2 of the PSR, and I've already brought this up to probation control. It shows that 15 years as opposed to 10 years. It's correct everywhere else in the entire PSR, except there's just one typo.
Okay. All right, the court will order that that be corrected. And Mr. Rolla, any challenges to the scoring of the guidelines?
No, Judge.
Anything on behalf of the people for allocation?
Briefly. Well, people understand that persons can behave differently in public than they do in private. It was somewhat perplexing when we got the, if you will, recommendation letter from the store manager, Miss Kristen Buckler. She describes the defendant's behavior as the utmost integrity and also, let's see, how does he? She also described him as a high degree of integrity and ethical behavior. Mr. Spillane is on his 4th felony. 3 of them are for meth, controlled substance possessions, and or offenses. He was on parole at the time, and while his behavior may reflect, one could argue, with all due respect, high on something, clearly not ethical behavior. So I'm not sure exactly why this letter got generated. I just found it rather odd, and I thought I'd bring that to the attention of the court. Thank you, Judge.
Thank you, Mr. Brown.
Your Honor, Mr. Spillane has significant drug history. He has been to prison for this. As the court is well aware, anybody that has an addiction problem, there are some issues with relapses, things like that. It's a very difficult thing to get over. He does have a lot of positive points. One of them is he is capable of doing successful things. He has been reporting as directed. I believe he's got good employment. He's had some negative drug screens there. And I think probably more of what that letter was about, again, was what they are seeing. And speaking to Mr. Spillane, because I've represented him in the past, quite frankly, in the past, he was homeless at times, sometimes desperate, turned to controlled substances in order to cope with some of the things he was going through in life. And quite frankly, he did inform me, and I can kind of see this to some extent, that he kind of gave up and just kind of didn't really care. He felt like he had absolutely nothing. Jail, prison, you know, he's going to have meals, he's going to have a roof over his head. Not that most people want to do that, but I'm not, or I wasn't in his situation. That might have seemed attractive, and the methamphetamines probably dulled his sense. Well, not probably, they definitely dulled his sense. But becoming addicted to that, it was a very difficult thing to overcome. He now has really and is trying to get his life back together. He has a good job. He actually cares about his future and what is going to be happening to him. So I would ask the court to take all of those things into consideration when fashioning a sentence.
Thank you, Mr. Spillane. Anything that you wanted to say?
Yeah. My counselor also sent a letter of recommendation also to Mayor Brown to get it to rule, but our prosecutor triggered, but apparently that didn't get it said. She said that I, had accomplished all my things that I had gone through, and like anytime like I had like trouble, I looked to like my support groups and my people that could help me out and get me out of those negative things. I get that what I did is wrong. I totally understand that. I'm not saying I'm perfect. Before I was homeless and I had not a care in the world. I was jobless. Now I'm not. I have a job. I've kept it for a year plus. My my boss actually is the one that bonded me out. She wanted me to come back to work. Like they're that dedicated of me, and they want me to be there because this was just a violation. It will never happen again. I know you've heard that before, but I'm not lying to you. I mean, I want to read what I wrote to you. I just want to say I'm truly sorry for the crime that I've committed. And I do understand that if I continue to go down that path, I'll lose anything and everything I love. I know and understand that the 50 days I did in county jail doesn't count, but it should, because it was a really good reminder of how fast that stupid drug can take away everything I have worked for, accomplished, and loved. I also want to say that I'm a way different person than I was before. I was homeless, jobless, with no cares. Now I have a job I love. I've been there for a year plus. I live with my girlfriend, who I love with all my heart, and she makes me want to be a better me. So please take all this into consideration when making your choice today. And again, I understand that this is a serious crime or violation, but I promise it will be my first and last. I'm done doing that. I've got a clear mind, and I'm ready to put all this behind me and move on with my successful life I've created for myself. So please don't take all this hard work away from me over one violation. And I have one payment left on my bail bondsman thing, and that's $250. That's going to be taken care of tomorrow morning, if you guys let me leave today. And then that $250 turns into $500, which will be coming here and be taking care of my court costs and fines within 3-4 months. It'll all be taken care of. I just want to say that I understand the severity of this, and I just don't want you to take everything that I worked for. Like, I get it before, that I understand that, I was being reckless and stupid and not caring, and I didn't have any cares for anybody else. But now I do care. I don't want this to ruin my life, and I really please and hope that you take that into consideration and don't take it from me.
All right. I read through the report, so I'm familiar with what happened in this case. And obviously there's a lot of information in that report about your background and your history and so forth. And, I agree, there's certainly some positive things. Number one, it appears that you did go for a decent amount of time while you're on parole without having violations.
Yes,
You were doing well, you were complying. And then, things kind of went south in this case, and you were found with a fair amount of methamphetamine, 7 grams plus. And so I think you certainly have the ability to comply with things like probation and parole, because you've shown that you do that. And I agree, I understand that relapses are a part of addiction and that they happen from time to time. Sometimes the consequences for those relapses can be more based on what you've had go on in the past.
Yes, sir.
Your parole status in this case, you knew what the stakes were being on parole, and you knew what the severity of offending again while you're on parole could result. And your past record gives you guidelines that are, pretty serious. You're looking at 10 to 28 months is what the guidelines are.
I understand that, and I'm really pleased. This will never happen again. It was a one in a lifetime thing, and like I said, that 55 days was a real good reminder of how this stupid drug will take everything I worked for and everything I love away from me.
Right.
And I really hope that you don't take it away from me.
Well, I'm not taking it away from you. Your actions are taking it away from you and what you've done, both in this case and in the past. I don't think that the sentence at the high end of the guidelines is warranted because of the positives, mitigating circumstances. And like I said, it could call for up to 28 months in prison. But I don't think that's appropriate because of the things that you mentioned. And those are considerations that I think take this from that upper end of the guidelines in spite of your past record. And I understand what you're saying about this isn't going to happen again. And I hope that it doesn't. But your past history doesn't show that that's what.
And my record though, I've never gotten in trouble. Last time I got in trouble was 2001.
Okay,
I don't have a bad record. Like I don't. When I got in trouble then, it's been since 2019 that I just now got in trouble. And yes, I get the severity of the crimes and trust me, I understand and I get it.
okay. I think a sentence in the middle of the guidelines is appropriate here. I think it accounts for your past history, and it accounts for your status on parole, and it accounts for what happened in this particular case. And a sentence in the middle of the guidelines is about 18 months. So the court is going to sentence you to 18 months in the Michigan Department of Corrections. And that's 18 months to
15, Judge.
15 years. That's the count one. Because of your parole status, you do not have jail credit.
Could I at least get work camp? I was on the board. Could I get
If
that?
you're eligible for the boot camp program,
No, work camp here. I was told I was eligible for work camp here.
you may be, but your sentence is to the Department of Corrections, not to jail. So because of your previous sentence, I doubt you are eligible for boot camp.
No, I'm not. I was in boot camp before. You told me no, and they let me out.
Yeah.
Yeah. So no.
So yeah, 18 months to 15 years. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and state costs of $68. You have the ability to seek an appeal of this sentence. We're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal. Brown, if you can let me know once Mr. Swin has acknowledged receipt.
Yes, Your Honor, he has acknowledged your receipt. I'm tendering that to the
Judge,
Yes,
you're gonna order, so that we don't get the order coming back from the Department of Corrections, that's to run consecutive to his any parole violation.
correct. Yes.
Thank you.
The custody of the county.
Hey, singer.
Those are copies of the copy.
Right, People versus Garrison, case number 36650 and 6651. Record should reflect Mr. Garrison's presence here in the court today. I could have counsel.
Records rendered by Colorado Valley Chief.
Garrison.
Mr. Brown, how do we want to proceed today?
Your Honor, if we could first proceed with file 6551.
Okay.
There has been an offer in this matter to plead to an added count to NSF between $105 or $100, $500. It's a 1-year misdemeanor or dismissal of count 1. Spoken with Mr. Garrison, I believe he is going to advantage of that offer.
Okay, that's not going to involve the resolution of the other file.
It is not.
Okay. All right, Mr. Rolla, is that a correct statement of the offer in file 6651?
Either there's some incorrect notes in my file or something, my laptop is just charts. Give me a moment, Judge.
Okay.
Ah, that's why, because somebody entered it under 6650, not 6651. Give me a moment. That's The plea offer is to add account to non-sufficient funds check $100 or more, but less than 500. Contrary to MCL 750-1313 B Baker 1. That's a 1-year, $1,000 misdemeanor for dismissal of count 1 with upfront restitution in the amount of $534.97 out of the 4 sentences.
All right, Mr. Garrison, have you had a chance to talk about this agreement with Mr. Brown?
Yes, other than this, the last part about the, when to pay the restitution, but.
Okay. Will you be able to do that before the sentencing date? That's going to be in about 30 days.
Close, I'll be real close, to be honest.
Mr. Brown, Mr. Rolla, do you guys want to discuss that a little bit further?
The court wants to move sentencing off for 2 months if he enters his plea down. We vote on the objection.
Okay. You do that. All right. And so with that being said, Mr. Garrison, do you want to enter that plea in that charge today?
Yes, I do.
You raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Mr. Garrison, as the lawyers have said, this charge is a misdemeanor. You're entering a plea to today. It's the same, basically the same charge, just involving a lesser amount. So the penalty is less. It's a misdemeanor with a maximum of 1 year in jail and a $1,000 fine. Do you understand that?
Yes, I do.
But are you currently on any kind of probation or parole?
No, I'm
Okay. So with that penalty in mind, what is your plea to that charge today?
guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all of those rights.
Yes, I do, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, I do, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, it is.
Are you pleading guilty because you are guilty?
Yes, I am.
Okay, so this information indicates this happened back in May of 2023, is that correct?
That's correct.
What happened with the check in here? Did you cash a check that you weren't supposed to cash, or what?
It was submitted to a business judge.
Okay, can you tell me what happened?
I submitted a check to Mr. T's Glass for work that they had completed. At the time, I didn't realize that there was no funds in the account to cover said check, and obviously there wasn't. So I'm guilty of it. Can't argue that.
Okay, did all of that occur here in Otsego County?
That's correct, Your Honor.
All right, Mr. Roller, are you satisfied with the factual basis?
Yes, Judge.
Mr. Brown?
Yes, Your Honor.
Mr. Roller, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Brown?
I am not aware, and I believe the court has complied with statute and court rule for taking place.
We agree as well.
All right, Mr. Garrison, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty. Added to the misdemeanor charge, the court will accept your guilty plea. Mr. Roller, well, we'll set this out. I think we need to make sure that we can get the plea agreement effectuated. So we'll set this out for a hearing in 60 days for sentencing. And Ms. Davis, if we could just have a misdemeanor PSI done, just outlining kind of facts of what happened. Mr. Roll, anything further on this file today?
No, Judge.
Mr. Brown?
No, Your Honor.
And then how did we want to proceed in the other file for today's purposes?
There has been a plea offer in the matter, Your Honor, to plead to count 2 for dismissal of count 1. I have gone over that offer with Mr. Garrison. At this time, I believe we are just going to set this matter for trial.
So Mr. Garrison, that other file involves different charges. At this point, you'd like to request a jury trial in that case?
Yes, sir.
Mr. Rolla, how much time do the people need to be ready for a trial? And that's in file 6650.
Correct, Judge. We have, looks like 7 witnesses, maybe a day and a half. At the outside, we might be able to get it done in 1 day. I don't know. Depends on how long it takes us to pick a jury.
I'll set it for a 2-day jury trial. And Mr. Rolla, do you need any particular time to be ready to go to
No,
trial?
Judge, all the notices, everything, we just have to do subpoenas.
Okay. Mr. Brown, do you need a particular amount of time to be ready for trial?
I could just look real quick. I would request at least 90 days if that's not too long.
Okay. Okay, so we'll set it out at least 90 days. The court will set this for a final status conference just before the trial date. So we'll have one more hearing before we have the trial, Mr. Garrison, and you'll be notified of the date and time of that hearing. Mr. Rolla, are you anticipating needing any motions?
No, Judge.
Mr. Brown?
Not at this time.
So, Mr. Garrison, that final hearing in this case before the trial, that'll be the plea cutoff. So to the extent that you want to further consider any plea offers, that would be the last day to enter into that before the trial. Do you have any questions about how we're going to proceed on that case?
So, Your Honor, excuse me.
Mr. Rolla, anything further on 650?
No, Judge.
Mr. Brown?
No, Your Honor, thank you.
Just make sure that you stay in touch with Mr. Brown as we go forward. And that's all for today. Thank you.
I do have some more questions.
I apologize.
So I have a physical address, but my mailing address does not match my physical.
Okay, what is your mailing address?
That will be P.O. Box 222, Vanderbilt, Michigan. I live inside the city limits. I don't have city code.
All right, thank you.
Thank you.
Okay. People versus Michael Allen Hoffman, case number 236599.
For the record, Judge, I don't have people.
Mr. Huffman.
Hearing is set for 2:15. It's now 2:20. It's like Mr. Huffman failed to appear back in January. Have you had any contacts from Mr. Huffman?
I had, Your Honor. I spoke to him in January. I spoke to him again 4 days ago. I was under the impression he was going to be here.
Looks like Mr. Huffman also failed to appear back in November. So that's 3. Mr. Brown or Mr. Rolla, I would just ask that your office prepare a warrant for Mr. Huffman's arrest. We'll proceed further on this case once the arrest is brought before the court.
Very good, Judge.
That's scheduled at the this morning. Literally 1 minute. We'll go on the record in People versus Maryland. Ruling, this is case number 236645. The record should reflect Ms. Norman's present here in court today. If I could have counsel for your appearance.
For the record, Judge, I told him.
Larry Brown on behalf of Ms. Norman.
Brown, how does you want to proceed in this case today?
Your Honor, this is a 2-count information. There's been an offer to plead to count 1 for dismissal of count 2, along with joint and several restitution to Walmart of $186. With the co-defendant, who was her daughter, who I believe actually pled a month or 2 ago. And it is my understanding that she's going to enter that plea today.
Wrong file. Please count 1, you said.
Yes, Your Honor.
Mr. Rolla.
That's correct, Judge.
Ms. Norling, have you had a chance to talk to Mr. Brown about this plea agreement?
I have.
And is that how you want to proceed today?
Yes.
You raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you. Ms. Norling, are you currently on any kind of probation or parole?
No.
And you understand that by pleading guilty to count 1, which is retail fraud, first degree, that carries with it a maximum possible penalty of up to 5 years and or a $10,000 fine or 3 times the value of the property. You understand that maximum possible penalty?
I do.
With that in mind, what is your plea to that charge?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Correct.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you have to ask the next higher court up, which is the Court of Appeals. Ask for them to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said on the record about the plea agreement?
No.
Is it your own free choice to enter this plea?
It is.
Are you pleading guilty because you are guilty?
Correct.
This happened back on August 2nd of 2023, is that correct?
That's correct.
And on that day, were you at the Walmart here in Gaylord and Otsego County?
I was.
And did you take some property out of that Walmart without paying for it?
I did.
And did you have any permission to do that from the store?
No, I did not.
And do you dispute that that property would have a value of more than $1,000?
No.
Okay. Mr. Roll, are you satisfied with the factual basis?
People satisfied the court's sufficient factual basis to accept the defendant's guilty plea as to count 1, has complied in accordance with statute as to accepting the pleas, and will aware of no threats, promises, or reducements not placed on record.
Thank you, Mr. Brown.
I agree there's a factual basis that the court has complied with statute court rule for taking pleas, and I am also unaware of any promises, threats, or inducements not placed on the record.
All right, thank you. Ms. Norling, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important prior to that you stay in touch with Mr. Brown so that you're ready to go forward on that day. Before you leave today, you're going to meet with Ms. Davis here from the probation department. She's going to set up a pre-sentence interview.
Okay.
Do you have any questions on it?
No, sir.
Okay. Thank you. That's all for me. Our next hearing is People versus Ashton. That's set for 2:45. So we will take a recess until that time.
Just to remind the court,
Yeah, Huron County, they signed in and they're connected, so let's just give it a minute here. Hi, good afternoon. We're looking for Miss Ashton.
Yes, we have her right here.
Okay, great. Thank you.
Thank you. Sorry about that.
No, you're good. Miss Ashton, are you able to hear me okay?
I'm sorry, what was that?
Are you able to hear me okay?
Yes, I am.
Okay, we're on the record now in People versus Nicole Ashton. This is case number 236543. The record should reflect Miss Ashton is appearing today by video from Huron County. If I could have counsel put your appearances on.
Yes, Judge, for the record, my fellow people.
Larry Brown on behalf of Ms. Ashton.
All right, and Mr. Brown, I know you were appointed to this case. The court intends to take some action with regard to Ms. Ashton's prior counsel, which, for the record, they were ordered to be here, both of them, 2:45 today. Neither of them is here in the courtroom. I will address that going forward. But in terms of today's representation of Ms. Ashton, is it fair to say that you've been appointed to represent her now?
I have, Your Honor. I believe received that back in January, about the 13th.
Okay, and Ms. Ashton, do you have any objection to Mr. Brown representing you for the purposes of this case at this time?
No, sir.
Okay. Mr. Brown, did you have any opportunity to speak with Ms. Ashton since you were appointed?
I did, and I have, Your Honor. Pull this up here, I apologize. I did have an opportunity to speak with her, and there has been a plea offer made in the matter to plead to an added count 2 for use of methamphetamine, a 1-year, $2,000 misdemeanor for dismissal of count 1. And it is my understanding that Ms. Ashton is going to enter that plea today.
All right, is that a correct statement of the offer?
It is, Judge.
Ms. Ashton, were you able to hear that?
Yes, I was.
And is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. And Ms. Ashton, are you currently on any probation or parole?
I was on probation for 7411 with the 7411 out of Charlevoix County. Not sure now that I'm incarcerated if that's a if it's a violation because I haven't been sentenced yet.
Okay, do you know?
I've never
you know
been
when
in
you
trouble
were-
before I moved to Michigan, so I'm not sure how this all works.
Sure, okay. Were you on probation in Charlevoix County in September of 2022? when this charge occurred?
Judge, I can assist
No,
with that if
sir.
you want.
No, okay. Do you have different information than that?
Defendant received 7411 on 12/2 of 2022.
Okay. All right. And so Ms. Ashton, you understand that by pleading guilty to this new charge of use of methamphetamine, that's a 1-year misdemeanor?
Yes, sir.
Okay. With that maximum penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all of those rights?
Yes, sir.
And you understand that you're giving up and waiving those rights by pleading guilty today?
Yes, sir.
Does anyone threaten you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here on the record today with regard to the plea agreement?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
Okay, as I indicated, the information I have indicates this happened back on September 16th of 2022. Is that the correct date?
I believe so, yes.
Okay, back at that time, were you here in Otsego County?
Yes, sir.
And at that time, did you have some methamphetamine?
I had a methamphetamine pipe.
Okay. Did it have some methamphetamine residue on it?
Yes.
Okay. Did you have any legal right to be in possession of any amount of methamphetamine at that time?
No, sir.
Mr. Roller, are the people satisfied with the factual basis?
People satisfied court is sufficient factual basis to accept her guilty plea as to added count 2 by the courtroom statute and the acceptance of pleas where no threats, promises, or other inducements not placed on the record.
Thank you, Mr. Brown.
I agree as well that there's a factual basis. The court has complied with statute, court rule taken pleas. I am also unaware of any threats, promises, or inducements that have not been placed on the record.
Thank you. Ms. Ashton, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of the misdemeanor of use of methamphetamine. The court will accept your guilty plea. Do you know how long you're going to be lodged there in Huron County?
Not yet.
Okay.
Your Honor, if I could, I believe I forwarded a message. I copied Mr. Rolla on this to Mr. Rohr. If there's a chance, we would like to move to immediate sentencing.
Okay, Mr. Rolla, are the people going to be asking for any jail time?
Judge, the charges she's got elsewhere are going to far exceed the time she's looking at in this county.
Okay, Ms. Ashton, do you have any objection to the court sentencing you right here today?
No, sir.
Have you had a chance to talk to Mr. Brown about that?
Yes.
Okay. All right, Mr. Roll, anything on behalf of the people?
No, Judge.
Mr. Brown.
No, Your Honor, as Mr. Rolla indicated, she's facing far worse charges where she is at currently. I believe she's been lodged maybe 6 or 7 days. I would ask the court to impose time served.
Okay, Ms. Ashton, anything that you wanted to say today?
I've been incarcerated since the 26th of January, just so that we're correct on that date. And that's it.
Okay, so 26. That'd be 12 days of credit.
Actually, Your Honor, I wasn't quite aware that she was incarcerated on that date. I filed a stipulation to cancel the bond on January 30th. I don't know if the court received it or signed it.
And Judge, that's the information we have, so at least as of the
30th. Okay. Got it. Okay, so Ms. Ashton, I think given your present circumstances and given the facts of this case based on what you testified to during your plea, I do think that, fines and costs would be appropriate with credit for time served. The court doesn't find that additional jail time on this charge would serve the interest of justice. So the court is going to impose 30, so you would be entitled to 9 days of credit. The court is going to sentence you to 9 days in the Otsego County Jail with credit for 9 days served, $130 of crime victims assessment, $68 state costs. Court costs in the amount of $325. Because of Mr. Brown's late appointment, the court's not gonna assess an attorney fee and $100 fine. Because this is a misdemeanor offense, we are not going to be providing you with any written appellate rights. However, Ms. Ashton, if you wanted to appeal this sentence, you would need to file the appropriate paperwork within the next 21 days. Mr. Rolla, think further on this case.
So, Judge.
Mr. Brown.
Oh, Your Honor, thank you.
Ms. Ashton, did you have any further questions? This will resolve this case and you'll have no further hearings before this court.
I have no further questions. Thank you.
Okay, thank you. And then with regard to Attorney Van Lan and Attorney Daly, again, both of those lawyers failed to appear as ordered for this hearing today. The court is going to institute contempt proceedings against both of them and schedule further hearings to address that issue. That's all we have for today, Ms. Ashton. The court's going to disconnect at this time.
Okay, thank you.
Thank you. Okay, our final hearing of the day is set for 3:15, so we'll take a short recess until that time. we're on the record in People versus Eller, case number 236520, 6521, 6522, and 6523. The record should reflect Mr. Eller's present here in the courtroom today. If I could have counsel put your appearances on.
The record showing Michael on behalf of the people.
Michael Varnish, Your Honor, on behalf of the defendant.
This is set for status conference in these files today. Mr. Barsh, can you tell me where we're at with these cases?
Your Honor, we are ready to enter to accept the plea offer from the people and enter a plea today.
Okay. Can I have you and Mr. Eller come up to the podium, and are there any of the files that are going to be dismissed in their entirety as part of the plea?
My understanding is there is a file that was in district court when I was up here last time that is coming up here, which I don't believe is made.
No, it's not going to come up here. It's going to be dismissed with restitution.
There you go.
And that would be district court file number 23-42150 If I may approach, we have a rather extensive global plea agreement.
Okay.
Might help the court.
Yes. But anyway, that new file that was just found over, that's going to be dismissed.
Correct. I didn't have a circuit court case number on it yet, otherwise I would have included it.
Okay. So I'm gonna just take these one by one. So we have case number 6520. File. Plead guilty to count one, and the enhancement will be dismissed.
That is correct, Your Honor.
And then in 6521. Also count one with the dismissal of the enhancement.
That's correct, Your Honor.
Counts 1 and 4 with dismissal of remaining counts and enhancements.
That's correct. Oh, and dismissal counts 2, 3, 5 through 12 as well.
Correct. And then in the final file 6523, plea to count 1, all other charges and enhancements dismissed.
That is correct, Your Honor.
Mr. Rolla?
That's correct, Judge.
All right.
Or at least I hope that's exactly correct, since that's what I gave the court.
Okay.
Do you need to reference the new file, Judge, is being dismissed or?
There is restitution also made as part and parcel of the plea agreement, Judge.
All right, and then the new file number 246686, which is not on the docket for today, but I have that file. That one's being dismissed in its entirety.
Correct, Judge.
Okay.
With restitution.
Okay. All right, Mr. Allard, have you had a chance to talk to Mr. Bardish about this plea agreement?
I have, yeah.
All right, and what I've just outlined is that the plea agreement that you discussed with him? Yes. Is that how you want to proceed today?
Yes.
All right. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Allard, are you currently on any kind of probation or parole?
No, sir.
Okay. So with regard to file 6520, you're going to be pleading guilty to one count of non-sufficient check funds of 500 or more. That carries with it a maximum possible penalty of up to 2 years and or a $2,000 fine or 3 times the amount payable. Do you understand that maximum possible penalty?
Yes, I do.
All right, in file number 6521, you'll be pleading guilty to one count of stealing or retaining without consent a financial transaction device that carries with it a maximum possible penalty of up to 4 years and or a $5,000 fine. Do you understand that? In file number 6522, you'll be pleading guilty to 1 count of overcharging of a financial transaction device. That carries with it a maximum possible penalty of up to 4 years and or a $5,000 fine. Do you understand that?
Yes.
And then finally, in file 6523, be pleading guilty to a count of non-sufficient check funds of $500 or more. Again, that is a 2-year and or $2,000 fine or 2 times the amount payable. Do you understand that maximum penalty?
Yes.
Mr. Bardish, are you aware of any potential consecutive sentencing sanctions that may apply in this case?
No, Your Honor.
So then, Mr. Eller, with all of those maximum possible penalties in mind that we just discussed, what is your plea to each of those charges today?
Nothing.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand all of those rights. You understand that you're giving up and waiving all of those rights by pleading guilty.
Correct.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the Court of Appeals, which is the next higher court up. You would have to ask them to hear your case. They could say no, and that would be the end of any appeal of the plea. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
No.
Your own free choice to enter this plea.
Yes.
Are you pleading guilty to each of these charges because you are in fact guilty?
Yes.
Given the nature here and the number, Mr. Bardish, are you prepared to take some testimony here?
I can do that, Your Honor.
Okay, thank you.
I'm just gonna go in I'm just gonna go by the numbers. So I'm gonna start with 6520. Mr. Erlard, on 11/14/2022, did you present a check the check that was written upon Community Financial Credit Union naming Go North Properties as the payee?
Yes.
And you presented that check to them. The check represented that there was an amount on that check of over $500 that check would be good for.
Correct.
And at the time that when you presented that check, you then moved the money out of the account that check was written on into a different account so that check would have non-sufficient funds. That account would have non-sufficient funds to cash the check.
Correct.
And you knowingly did that.
Yes.
And that occurred here in the county of Oswego.
Correct.
I have a factual basis for that account.
People satisfied, Judge.
All right, thank you. So that covers 6520.
Now moving on to file 6521. On or about, Mr. Deerhart, on or about January 6th, 2023, did you use a credit card or other financial transaction device that belonged to a Mr. Martin John Van Til? And you used that credit card to purchase items, correct? And at the time that you used that credit card, that item to purchase items, you did not have the consent or the permission of Mr. Van Til, the device holder, the owner of that card, to utilize that credit card to make those purchases. And you did that knowingly. And that occurred.
Judge, there's 2 counts, so we're gonna have to distinguish that on the record.
Hold on, first things first. Mr. Eller, I'm having trouble picking up your voice. I just need you to speak up a little bit.
I'm sorry, Your Honor.
Recording this for the record.
Okay, I apologize.
Roll up mic. On this file, I only have one charge.
Oh, I'm sorry, which, we're right, 2-1, okay, I'm sorry. I thought he had said 2-2. Apparently I didn't hear him either, so thank you.
And this occurred in the county of Otsego.
Correct.
I think I formed a sufficient factual basis, Your Honor.
As to that charge.
People satisfied, thank you.
Thank you.
I am now moving on to file number 236522. On or about between the dates of December 27, 2022 and January 5th, 2023, were you here present were you here present in the county of Otsego?
Yes.
And did you knowingly overcharge the credit card of an individual by the name of Barbara Goward?
Yes.
And you overcharged this credit card for an amount more than she had authorized you to charge that credit card, correct? And you did that knowingly. Your Honor, I think that's a sufficient basis for count one, is that correct?
In that time frame, and here in Otsego County, did you do that at least twice, Mr. Eller?
Yes.
Okay.
I apologize, Your Honor. Just
Correct, Judge, thank you.
Nope, it's a bad question on my part. You're fine.
All right,
I think you have a factual basis, Your Honor.
yes.
And then moving on now to file number 23. Mr. Erler, on or about or between the dates of 11/24/2021 and 12/22/21, did you present a check to an individual by the name of Matthew Collins that was written on a Horizon bank account for purposes of paying a debt?
Yes.
And on that check represented that there was an amount on that check that was in the account upon which that check was written upon, that was sufficient enough to cover the money promised in the check.
Yes, sir.
And at the time that you presented that check, you knew in fact that the account did not have sufficient funds to cover the amount that the check was written for. And you did that knowingly.
Yes.
And that occurred here in the county of Otsego.
Yes.
I think we have a factual basis. for
Amount
that.
of the check, Judge. The amount of the check.
Oh, and the amount of the check was over. Over $500.
Yes.
People satisfied, thank you.
Thank you. Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
Other than the restitution condition, no, Judge.
Mr. Parrish.
That is correct, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Mr. Parrish.
That is correct, Your Honor.
Mr. Eller, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of the charges alleged. The court will accept your guilty plea as to all charges. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. And prior to that, you're going to have a pre-sentence report done. You're going to meet with Ms. Davis here from the probation department before you leave the courtroom to set up a date for that. Other than that, it's just important that you stay in touch with your attorney so that you're prepared to go forward.
I do have a quick question.
No, we don't. We have no further questions.
Thank you, Mr. Rolla. Anything further today?
No, Your Honor, thank you.
Mr. Parrish.
Thank you, Your Honor.
Thank you. That concludes the court's afternoon back at the court of recess.